As everybody knows, COVID-19 pandemic has caused arguably unprecedented peacetime loss and damage to lives and livelihoods across the globe. And the insurance industry is shared in this loss. Estimates for the amount that's been paid out by the insurance industry vary from $44, $45 billion to in excess of $100 billion. No one's actually exactly sure how much is being paid out because of the variety of different types of statistics and the inability to actually get all those statistics collated. But I think that a payout of in the region of 40 to 50 million US dollars is probably a conservative estimate. It's in light of that payout and the wider loss, because it's not just about money, to industries and people and communities across the planet, that I look at the effect of COVID-19 and the response to it in the form of insurance, specifically in the form of pandemic insurance. And I look at some of the litigation that's surrounded that insurance and its absence over the past 2 years, and also what we think may happen in the future, because there will be more pandemics. And in fact, moving on to my first slide, Lloyd's of London issued a report way back in May 2008, Pandemic Potential Insurance Impacts. Its opening words were, "A pandemic is inevitable." Now that's 15 years ago. The report referred to a number of historical pandemics, not just Spanish influenza, but others. It referred to potential pandemics in the future. It actually identified as the big baddies, the main risks, as being from MRSA and influenza. And it should be noted here and now that even though we've just had a major pandemic involving SARS-related illness, that those two other threats are still out there. MRSA, anti-medicine resistant germs, and influenza. And we've had outbreaks of bird flu again recently. Now, despite the fact that a pandemic was inevitable, Lloyd's noted that there were few and far between any pandemic-related insurance products, despite the fact, and I quote from it here, "Many classes of business will be affected by a pandemic. Clear-cut cases involve health and life insurance, other forms of cover, everything from directors and officers cover, general liability, event cancellation," for which we can read business interruption. "Policies may be affected depending on policy wordings and judgments." And again, two operative words in that sentence, policy wordings, because one of the things I will focus on and reiterate throughout this talk is the importance of policy wordings. Now, as I said, little tangible action is taken in the 15 years between 2008 and now, and between 2008 and 2019, when the report was made and when COVID-19 began. One or two pandemic risk insurance policies have been developed. Pathogen X is one of them, which I will talk about later. But insurers were reluctant and remain reluctant to develop such types of policy. Now, you may ask why. Some of you may think you have an answer to that. Well, the answer is the huge losses associated with pandemics, which arise from uninsurable correlated risks. Now, there are other types of this type of risk: earthquakes, widespread floods, tsunamis, etc., what we usually call natural catastrophes or NatCat risks, which result in multiple losses in the same geographical area at the same time. Now, that in and of itself is difficult for insurers to address because it undermines the potential for risk sharing, which is one of the essentials of insurance. But pandemics are worse than that because the losses are not restricted by geography. To recall a title of a film that's just won several awards, with a pandemic, it's everything all at once, everywhere. multiple losses, multiple locations, usually at the same time, but can recur over weeks and months afterwards, which makes the establishment of the extent of the risk, the setting of premiums, working out how much you would have to pay out in claims, almost impossible, which is why insurers have avoided writing such types of cover. As I say, there are some exceptions, and we'll see how they have fared. In the absence of any specific pandemic risk cover available for businesses, the bulk of claims made in relation to losses arising from the pandemic have been against business interruption insurance, or similarly termed cover in various jurisdictions. Most of the industry's losses of $45 billion that have occurred in the past couple of years have been in relation to business interruption insurance. But the point remains, and the essential point remains this, is that there is, despite all these losses, despite the fact that claims and litigation have been brought in respect of BII cover, no new comprehensive product, by which I mean one that covers a variety of losses over a period of time in a particular jurisdiction or number of jurisdictions, or scheme, public-private scheme with government involvement, is in place to meet the next inevitable pandemic. There are some local schemes of limited effect, and I will mention one or two of those, but there is no comprehensive insurance product or scheme, public or private, in place in any of the leading jurisdictions. So what we're going to look at today, I'm going to look at the nature of business interruption insurance, how the cover has responded to COVID-19 related claims, and business interruption insurance and possible alternatives to BII cover in response to future pandemics and catastrophes. So, most BII cover is written either on a UK or US form or wording. Now, that's not to suggest that the UK and the US are the only countries that matter when it comes to addressing issues about pandemic risk insurance. That's far from the case. Many other jurisdictions have cover in place. Many other jurisdictions have suffered huge losses. But the point is, in most of those jurisdictions, the cover for this type of loss is written in a manner similar to that of the UK or US, which means that the way that the courts in the US or the UK interpret those policies will have a bearing, even though courts in the jurisdictions are not obliged to follow UK or US courts, but will still have a bearing on the way that insurers respond to claims against BII cover in other jurisdictions. For example, Norway, Poland, India, all of which follow the UK style wording for their BII cover. What's the point of it? What is the purpose of BII cover? Well, it's long established law in the common law world that an ordinary insurance policy, an ordinary property policy, will not cover the policyholder for lost profits or markets. BII cover is a form of financial insurance that's designed to plug that gap. An insurance against pecuniary loss, as it's sometimes termed. It is intended to place the policyholder into the same financial position it would have enjoyed had its business operations not been affected by the insured peril. And traditionally, those insured perils would be fire, flood, which would prevent the continuance of its business operations. An important thing to appreciate is that the cover is not that widespread. I mentioned that people are reluctant, don't tend to buy pandemic cover even when it's available, but many people don't bother buying or didn't bother buying BII cover. In the US, it's suggested that around about 29% of small businesses have got this type of cover immediately prior to the pandemic. In the UK, it's possibly no more than 50% prior to the pandemic. In China, it's even smaller. In China, BII cover forms part of enterprise property insurance, which itself forms only about 4% of all property cover. So it's a tiny part of property insurance. Now, insurers, following the beginning of the pandemic, have argued that BII cover is not intended automatically to cover pandemics or losses from similar types of disease outbreak. They've said it depends on the wording of the cover. Now, policyholders have objected to that, and that's why we've had so much litigation going on. But the important questions for the consideration, and again, I emphasize the importance of a policy wording, for BII cover, along with any type of insurance cover, is the identity of the policyholder, the insured perils, which may include a pandemic or not, the duration of the cover, the measure of indemnity, namely how much can you expect to get back from the insurer, and any exclusions. So the answers to all of those questions, all of those issues, are found in the policy wording. And I appreciate I might start to sound a little repetitious or boring when I keep saying this, but it is fundamental. And a point that's often been ignored in the arguments in the courts and elsewhere about cover for business losses arising from COVID, it depends on the policy wording. And many people, both insurers and policyholders, haven't appreciated that fact. Who or what is covered? It usually forms part of a policyholder's commercial property insurance, which is usually written on an all risks basis. And one of the ironies of all risks is that after one reads the policy wording, one discovers that all risks are not actually covered. As it's usually part of a property policy, the primary insured peril in BII cover tends to be some form of physical damage or disruption, fire or flood, to the policyholder's business premises. And the necessity for physical damage has been emphasized in numerous cases. I've not listed this one, but a recent one, TKC London Limited and Allianz Insurance, which was a COVID-related case, where it was stressed that the fact that a cafeteria, a restaurant, had been shut down because of COVID, which led to its stocks going out of date, was not physical loss. It actually was wear and tear to those physical stocks. So no cover. If those stocks had somehow been destroyed, lost in a fire or flood, or somehow become contaminated, that would be different, but it wasn't. There needed to be physical loss. Now, the reason why we have cases such as FCA and Arch in the UK and other litigation is because there are also secondary triggers for BII cover, sometimes part of the main wording, sometimes as extensions to cover. And they can cover other triggers other than physical damage. But they still usually relate to the policyholder's premises or immediate physical environment. And it's the nature of those secondary triggers that have been at the heart of much of the litigation, including in the UK, about whether or not BII cover covers pandemic-related losses arising from COVID-19. Some insurers also provide even more esoteric extensions. For example, Hiscox. It will cover the policyholder for, quotes, losses arising from employees resigning from employment with you during the period of insurance as a direct consequence of their securing a win in a lottery So if you lose staff because they win the lottery and they're key members of staff, you can get cover for that. But I must say, such extensions are pretty, well, they're not that common. Hiscox is quite generous in this respect. Most of the extensions relate to the premises themselves, the business operations themselves. And we'll look at some of those extensions in a few months when we look at some of the litigation. In the US, and I've just mentioned the UK type of wording, in the US, the US Insurance Services Office issues a number of standard policy wordings, some of which are adopted by other insurers with some tweaks, but they're pretty common. The business income and extra expenses, what's known as BII cover form, is the most widely adopted form of wording in the US. And it says, we will pay for the actual loss of business income you sustain caused by direct physical loss of or damage to property at premises which are referred to in the policy wording. Another form of cover, which is the business owner's policy, also is predicated on direct physical loss of or damage to property at the insured premises. You can get extra cover for the prohibition of access to your property because maybe the authorities have closed down the local roads or anything like that, or collateral damage as a consequence of one of your suppliers not being able to operate. But again, those extensions are also predicated on direct physical loss of or damage to property. So maybe your supplier's factory has had a fire, or maybe the local roads have been closed, so you can't have access to your property, but that road closure is a result of, again, a fire or flood or something. The centrality of direct physical loss to both primary and many of the secondary triggers in US cover is essential. You cannot ignore it. And again, much of the litigation in the US is as a consequence of the fact that that's the nature of the damage that's covered, and people have disputed as to that. Australian policies, as with Poland and India, tend to follow the UK wording. Canada, Mexico, and Japan tend to follow the US type of wording. Duration and indemnity. In the UK, you usually get cover for 1 year, and you will recover any losses you suffer for the duration of that 1 year. Australia, again, follows the UK approach. In the US, it's a little different. What tends to happen is that the policyholder will be covered and indemnified for a period referred to as a period of restoration. That usually starts about 72 hours after the occurrence of the direct physical loss and ends when the premises are repaired, rebuilt, or are working again or operational again, or should have been repaired with reasonable speed. And interestingly enough, in the US, the expiration of the policy wouldn't stop you recovering if the period of restoration was still ongoing, whereas in the UK it would. Cover in the UK is usually written on a gross profits basis. And that was traditionally calculated as a combination of net profit and standard charges. Cover in the UK is now written on what's called a difference basis, which is determined by taking the turnover and then subtracting variable charges. European insurers have tended to follow the traditional approach. In the US, cover is written on a business income or gross earnings basis. So you can already see a wide variety of ways of calculating what the losses actually are. And this, again, has led in the past to a lot of confusion and a lot of litigation in terms of what the insurer thinks is a gross profit and what, for example, their accountants or the tax authorities might think is a gross profit. Exclusions. I've already mentioned one case, exclusions for latent defects, wear and tear, the usual exclusions for terrorism, war, fines and penalties, trends clauses. And these were important in the FCA and Arch litigation. Trends clauses essentially restrict your losses by reference to the overriding economic circumstances at the time. If, for example, your factory has a fire at the beginning of a recession, your loss will be adjusted by how much the recession may have caused a downturn in your turnover, therefore your gross profits, in the time which your factory wasn't operating. You can't just look at the historical performance of your factory. Trends clauses are designed to eliminate from recovery factors which would have been uninsurable, such as a downturn in the economy. There are also deductibles rather, excesses. Cover is voided if the business is wound up. And there are also exclusions, and this is included in the standard ISO US wordings for virus and pollution. So what we have here is the fact that BII cover is a precise rather than broad form of insurance. It's designed to ameliorate the financial difficulties that a policyholder suffers as a consequence of an insured peril, usually fire, flood, or can be something else. The problem is these policies have been designed, developed, implemented on a very ad hoc basis. Yes, in the US, we have the ISO issuing general policy wordings, which some people have adopted and others have not. In the UK, no such thing, which is why we had so many insurers who were involved in the FCA Arch litigation, and many more insurers who were not, whose policies may or may not have been affected by the outcome of the Supreme Court's decision. And it's also the reason why we've had so many difficulties, why we've had the litigation, because the policy wordings differ. And people have become quite agitated by this. And we've had politicians agitating about this and demands for the cover to be extended automatically. And I will discuss those demands later. They are not demands which I regard as being sensible demands for various reasons, some of which will have occurred to you already, and which I will go into later. But one cannot avoid the fact that because of the rather ad hoc manner in which BII cover has been developed over the years, a lot of people are not happy with insurers' response to claims brought about by the pandemic. And that's what we're going to look at now. Now, I see we've got one chat question. Okay, I'll deal with that later. If you have any questions, again, post them on the chat and we'll deal with them at the end. So, BII and COVID-19 claims. The United Kingdom. Financial Conduct Authority, FCA and Arch. Now, this was an unusual piece of litigation in that it was brought in advance by the regulator to determine what the response of a selection of BII policies would be in the event of claims by the policyholders. It was intended to prevent litigation popping up here, there, and everywhere, and potentially conflicting judgments by the courts. Let's have one decision at the beginning, and it may well not apply to every single policy, and certainly it won't do because policies differ, but at least then we've got a general view of how the courts will respond to such claims. it eventually reached the Supreme Court. Before it got to the Supreme Court, it was dealt in the High Court by Lord Justice Flaw and Mr. Justice Butcher. And they considered 21 lead BII policy wordings issued by 8 insurers. I'll tell you who they were. Arch, as you would expect. Argenta, Ecclesiastical, 4 by Hiscox, MS Amlin, QBE, Ralston Alliance, and Zurich. Those were the 8. 21 of their policies. And then you have 8 insurers, 21 policies. So already we're getting a multiplication of possible policy wordings, even with just 8 insurers. The FCA estimated that a further 700 policy wordings provided by another 60 insurers to up to 370,000 policyholders could be affected by the outcome of this case. Now, it was agreed by all the parties before the High Court that there was no cover under the primary trigger of physical damage. So what the court looked at, the High Court and then Supreme Court, were the following 3 categories of secondary trigger. The first was disease clauses. These cover losses arising from the occurrence of a notifiable disease, and it's down to the authorities to determine what a notifiable disease is. COVID became a notifiable disease, within a specified distance of the insured premises. That specified distance varies, but generally speaking, at least in this litigation, it was within 25 kilometers of the insured premises, within a radius of that nature. Prevention of access clauses. They provide cover where access to or use of an insured premises is prevented or hindered by the government or some other public authority, such as the police. And hybrid clauses. They cover both restrictions by government authorities and the occurrence of a disease, a notifiable disease, within that distance of your insured premises. And the High Court also looked at trend clauses and the leading decision in Orient Express. And I'll cut short this point. Orient Express is no longer good law. Both the High Court criticised it. It couldn't overturn it because it's a High Court decision. But the Supreme Court expunged, as it were, Orient Express. Now, on these 3 types of clause, essentially, and I'm not going to dwell too much on the High Court because the Supreme Court came along, the FCA and acting on behalf of policyholders won. And therefore the matter went to the Supreme Court, bypassing the Court of Appeal under a special leapfrog procedure. And at the beginning of their judgment, the Supreme Court said this, and again, it's why I keep stressing policy wordings. The core principle is that an insurance policy, like any other contract, must be interpreted objectively by asking what a reasonable person, with all the background knowledge which would reasonably have been available to the parties when they entered into the contract, would have understood the language of the contract to mean. It's all about the policy wording. Irrespective of everything else the Supreme Court subsequently said, it's about the policy wording. Now, the Supreme Court accepted the insurer's submission that each individual case of COVID-19 was a separate occurrence, rather than part of some greater collective occurrence, which is what the High Court had said. And it also accepted that disease clauses only covered losses arising from individual cases within a specified distance of the insured premises. So the insurers were pretty happy at that, because one of the things they didn't like about the High Court was that it seemed to suggest that COVID-19 was some sort of Hegelian overarching occurrence, irrespective of where an outbreak may have taken place. I'm very, very old-fashioned. I was educated many years ago, and I said House of Lords, Supreme Court, I should say, however, overturned the High Court's view that prevention of access and hybrid clauses would only be triggered when some restriction by the authorities was actually set down in law. You may be aware that the government in the UK and other jurisdictions announced various restrictions, lockdowns, as the term goes, prior to those actually being entered into law by way of regulation. It was often a couple of days difference. What the Supreme Court said was it didn't matter. If a restriction had been announced by the government, that's when it became effective vis-a-vis one's policy. The fact that it might not actually have been implemented in law at that point didn't matter. And of course, as you can appreciate, that may have made a massive difference in the type of recovery that policyholders could expect. What it said was the clauses would be triggered if such public action carries the imminent threat of legal compulsion or is in mandatory and clear terms and indicates that compliance is required without recourse to legal powers. So if the government says, close down your shop, close down your business, it will trigger the policy. Now, arguably, and people have been arguing about this in the 2 years since the judgment came out, the most significant section of the judgment is that the Supreme Court held that all cases of COVID-19 which had occurred by the date of any action by the authorities, the lockdowns, were a proximate cause of that action. It was therefore enough for a policyholder to demonstrate that there was at least one case of COVID-19 within 25 miles, 25 kilometers of its premises at the time of the government action. So we don't need to worry about the fact that each separate COVID-19 case is a separate occurrence because they're all part of one proximate cause. Their lordships, the Supreme Court, rejected the insurer's contention that the but-for test should be applied. So, but for this case of COVID-19 within 25 miles, we could have kept operating. No. And this is significant. The Supreme Court said that the but-for test, and this has been said by the courts on many occasions prior to this, is just the beginning of the examination of causation. There can be situations where a series of events all cause a result, although none of them was individually either necessary or sufficient to cause the result by itself, which is a serious departure from the but-for test, but not unprecedented. And again, it's restricted in the sense that, again, it still comes down to policy wordings in the context of insurance. And obviously, this is an exceptional circumstance, i.e. a pandemic. And in terms of any other restrictions, the lordships also said it would be contrary to commercial intent of the policies if uninsured cases of COVID-19 deprived policyholders of compensation for losses caused by cases which they did cover. Now, this is all wonderful news for policyholders. But again, after saying all this, and obviously upsetting insurers a great deal, but their lordships said all that matters is what risks the insurers have agreed to cover. We have already indicated that this is a question of contractual interpretation, which must be accordingly be answered by identifying objectively the intended effect of the policy as applies to the relevant factual situation. So again, their lordships come back to this point. You insurers have sold policies that cover disease, prevention of access, and a hybrid of those. You cannot now hide behind the language of the policy to try and avoid those consequences. And the whole point of the policy was to cover losses rising from those consequences. Now, That doesn't mean that every single claim by every single policyholder in respect of COVID-19 is going to be met by the insurer. And there are a number of other cases. Rockcliffe Hall and Travelers Insurance Company, the policy there named 34 infectious diseases. COVID-19 was not on that list. No cover. An arbitration award issued by Lord Mance, certain policyholders in China Taiping Insurance. He stressed the importance of contractual construction and its context. When interpreting a contract, a judge should avoid rewriting it in an attempt to assist an unwise party or to penalise an astute party. So if you've not looked at your policy wording properly and ensured that you are covered for the things you want to be covered for, tough. There have been some subsequent decisions in the courts towards the end of last year, but none of it changed the overriding effect of FCA and Arch. Then essentially in the UK, depending on the policy wording, but for the majority of policy wordings, where there are disease, POA or hybrid clauses, cover will be available. That is in contrast to the United States. I have here, you might not be able to see it, this is a little map. This is from, right, it won't show. Professor Tom Baker of the University of Pennsylvania has been maintaining a COVID coverage litigation tracker. If you go to Google and type in Tom Baker, it's spelt the way it sounds, University of Pennsylvania COVID tracker, it will bring up that page I just tried to show you. I've not put it on a slide because it wouldn't show up very well on a slide. He has listed in that tracker, he and his team, hundreds of decisions in state and federal courts in relation to COVID-19 related claims against insurers. The majority of those claims are in respect of BII cover. Important thing to appreciate, on motions to dismiss, so not even going to full trial, motions to dismiss in state courts, 3/4 of them have been dismissed. Motions denied in only about 20%. Others, hybrid sort of a decision. In the federal court, something in the region of 80 to 90% of motions to dismiss by insurers against claims brought by policyholders have been successful. So the US courts overwhelmingly have been unimpressed with claims by policyholders for the losses arising as a result of COVID-19, and they sought to recover those losses from their insurers. Dime Fitness is one such case. That was in Florida. The policy said, we will pay for direct physical loss of or damage to covered property at the premises described in the policy caused by or resulting from any covered cause or loss. The court said, well, there's no physical damage. And this has been at the heart of the litigation in the US because of the wordings in the US puts the onus on physical loss and damage, and they also often carry those virus and pollution exclusions. And even when they don't, the court has said that doesn't make any difference. There's no physical loss or damage. Because of that emphasis, no claim. Other litigation elsewhere in California, although, and this is an interesting case, Huntington Ingalls. This is a case in Vermont, where the Vermont Supreme Court, and this is only one of 3 decisions on physical damage, which has gone in favor of policyholders, although they haven't won yet. The Vermont Supreme Court upheld a policyholder's claim that a virus may have caused direct physical damage. Now, the policyholder here is the largest military shipbuilder in the US and was covered against all risks of direct physical loss or damage to property, including loss due to the necessary interruption of business conducted by the policyholder, whether total or partial, caused by physical loss or damage insured herein. It sought a declaratory judgment against its reinsurers that it was entitled to coverage for property damage, business interruption, and other losses as a result of COVID-19 and related government action, i.e. it couldn't operate, it couldn't build ships. It argued that the pandemic caused direct physical loss or damage to property when the virus adhered to surfaces and remained in the air at its premises. Now, before the discovery stage of the proceedings, so we're still very early on, as with Hong Kong litigation, you have pleadings, you have discovery, or disclosure as it's called in England, Wales, you have witnesses, experts, etc., etc. So a very early stage of the proceedings, the insurers sought and obtained judgment on the pleadings in its favour, basically saying, no, this is not a runner. Before the lower court, the Supreme Court didn't actually say that the policyholder had suffered direct physical loss. It decided that experts and evidence should come in to evaluate the validity of the insured's novel legal argument before dismissing the case. So it's basically saying, well, let's actually look at this. Let's get the expert witnesses in who can say, is physical damage the same as viruses adhering to the surface or lingering in the air of the premises? Now, this decision runs counter to just about every single other decision, bar two, one in California, one in Louisiana. And I'm afraid the Louisiana decision, I've looked at it, and it is, I don't wish to sound pejorative, but it's odd, it's peculiar. In Louisiana, they actually followed precedents relating to asbestosis and methamphetamine, rather than other cases involving diseases, including cases involving COVID-19 before the Louisiana Federal Court. But going back to Vermont, this is one of just 3 decisions which have been in favor of policyholders when it comes to the question of, is COVID-19 a cause of physical damage such that it would be covered by the usual BII policy wordings? It's not decided absolutely yes. Louisiana decided yes, but the wording is strange, and it will no doubt, it might well, it was in a lower court, it wasn't in Louisiana Supreme Court, it may not go further. And even if it sticks in Louisiana, it probably won't go beyond that state. In California, there are conflicting decisions either way. The Vermont one is the only decision by a Supreme Court in a state that's pro-policyholder. If people here know about Vermont, Vermont's particularly liberal in its approach, politically and in terms of its court decisions. So again, it's a decision which may not go much further beyond that state. The preponderance of decisions, both in terms of motions to dismiss and other applications and rulings by the court, are overwhelmingly in favour of insurers. In Australia, there are 2 test cases. The first one was HDI Global Specialty in Wonkala, and that related to exclusion clauses. And that went in favour of the policyholders. Unfortunately, the second test case was in relation to cover generally. And in that case, the policyholders lost, the insurers won. As in FCA and Arch, the court, and it was Madam Justice Jago, looked at hybrid clauses, so the same as those in the UK, infectious disease clauses, the same as those in the UK, essentially, provision of access clauses, again, just like in FCA and Arch, and catastrophe clauses. Those cover losses arising from the action of authorities during a catastrophe for the purposes of retarding, stopping that catastrophe. Now, in the federal courts, the judge held that infectious disease clauses were the only ones which could provide cover in the event of losses, depending on the circumstances of the case. She also held that the pandemic, despite the fact that many people may disagree, was not a catastrophe but it was not a catastrophe within the meaning of the policy wording. And I will read out what it says, and you will understand why she made that decision. The insurer will indemnify the insured in accordance with the provisions of Clause 10 against loss resulting from the interruption of or interference with the business, provided the interruption or interference is in consequence of the action of a civil authority during a conflagration or other catastrophe for the purpose of retarding the same. So conflagration, we're talking about a fire or something like that, not a disease. The judge also held that provision of access clauses, hybrid clauses were not triggered because the lockdown orders in Australia, issued by various states and national authorities, were not issued due to an outbreak of COVID-19 within the vicinity, 25 kilometers, whatever, of a policyholder's premises. And she declined to follow the approach of the Supreme Court in FCA and Arch. She said, FCA and Arch contains much which is useful. However, it is necessary to recognize that their lordship's reasoning depended on the proper construction of specific insuring clauses in the context of the policies as relevant in that case. The relevant context being that the outbreak of COVID in the UK was termed as a national outbreak. The outbreak in Australia was, in the words of the judge, materially different. It was not a national outbreak. It was a series of individual ones. An interesting point was made that if one took a map of the UK and applied the 25-kilometre radius circles thereof over the map of the UK, it would rapidly be covered completely with not that many circles. The same clearly could not be said of Australia. That was one of the big differences. As a consequence, because the context is different, because the language of the policies is different, the Australian courts would not follow the UK's approach in FCA and Jago. Now, the full court substantially agreed with her conclusions. It's one difference being in terms of the effect of state-backed compensation available to policyholders. What it said was FCA and Arch has no bearing on the present cases before the Australian courts because the relevant circumstances underpinning the issues in FCA and Arch are substantially different from theirs which occurred in Australia and rather unique in themselves. So the Australians, generally speaking, are not following the UK approach, not following the US approach necessarily either, because the policy wordings on some occasions, infectious disease clauses, will allow a recovery, but FCA and Arch is not going to run in Australia. The Irish courts in Leopardstown and FBD actually followed the High Court approach, albeit with some other views of its own. Mr. Justice MacDonald said he agreed with which was what was said by the High Court in FCA and Arch, although he came to the same conclusions on it for his own reasoning. So it runs there. In South Africa, they also like the High Court's decision in FCA and Arch. So as you can see, on an objective view, whether or not a policyholder succeeds in its claim for cover for losses arising as a result of COVID-19, whether or not it's a occurrence of the disease within the premise, near to or at the premises, or because of government actions, a consequence of an occurrence, is dependent on the policy wording. In the UK, large number of policies will cover it. Some clearly do not. The US, most policies will not cover it. It may be that almost all policies don't cover it, with some exceptions. Who knows? Maybe Louisiana judgment, the California judgment, Amy's Kitchen's the name of that case, and the Vermont judgment, Huntingdon. Who knows? Maybe some other judges will pick them up, but it seems unlikely. In Australia, yes, there will be cover, but again, not widespread. And certainly in none of these situations is cover automatic. It depends on the policy wording. And the debate, as I've already said, about whether or not COVID-19 pandemic losses should be covered by insurers or not has been conducted in many respects in ignorance or avoidance, for want of a better way of putting it, of that vitally important fact. When we talk about coverage gaps or protection gaps, that businesses can't get cover for their losses, it should be recalled that they didn't buy cover for those losses. Now, one can have arguments about whether or not they were misled, and that's a legitimate argument to be had if they thought they were being sold policies that would cover such losses. But if the wording is clear, you don't get what you didn't pay for. And many people didn't pay for it. So, where does this leave us in terms of future pandemics? By the way, this is not beer. I'm not drinking at lunchtime, not in the serious way. It's actually dandelion and burdock for those of you who are interested in what I'm drinking. Probably nobody. Now, how do we deal with these coverage gaps? We're in the same position we were 15 years ago. There is no, other than say some BII policies are not in every single jurisdiction, there is no fundamental comprehensive cover for such losses. And even where there is cover, insurers are responding to close those gaps or to stop that cover. The Lloyd's Market Association has published a model communicable disease exclusion for use in liability policies. And I'll read this out to you. All actual or alleged loss, liability, damage, compensation, injury, sickness, disease, death, medical payment, defense cost, expense, or any other amount, directly or indirectly, and regardless of any other cause, contributing concurrently or in any sequence, originating from, caused by, arising out of, contributed to by, resulting from, or otherwise in connection with a communicable disease, or the fear or threat, whether actual or perceived, of a communicable disease. I'd call it a pretty comprehensive exclusion. That's in the LMA model wording. And I dare say it, or clauses very much like it, have been adopted by many insurers in the years since COVID kicked off, if they didn't already have such exclusions in place. Given that at the UK at least, the public cost of COVID-19 in terms of the relief measures has been in the region of £376 billion, and another £132 billion being loaned or guaranteed by the Bank of England, one can understand why people are concerned about the financial impact of another pandemic. In the US, it's actually estimated that 4.6 trillion US dollars have been spent by the authorities addressing COVID. In Australia, and we've mentioned Australia already before, about 291 billion pounds, sorry, $291 billion Australian dollars has been expended in terms of COVID relief. So one can understand why governments, politicians, and insurers are concerned about how we address the next, and it will happen, the next inevitable outbreak, be it of some form of MRSA, influenza, or maybe another SARS-related illness. So, how do we deal with this? How do we deal with all these businesses having massive losses which they may not be able to make good? Why not extend BII cover to pandemic losses? Well, is that realistic? Well, we already know that there may be something in the region of 700 policies in the UK that may cover such losses, but I dare say many of those insurers have since changed their wordings and may have included something very much along the lines of the LMA exclusion. One could argue, why should they have to cover these losses? Again, their policyholders have not necessarily paid for them. Many of you will recall that in the wake of the SARS epidemic, almost 20 years ago now, many Hong Kong-based insurers altered their wordings to exclude losses arising from diseases, pandemics. That was the source of the exclusion by the US ISO to its standard wordings to exclude diseases, viruses, and to some extent pollution as well. The UK government, when asked about should we, as a nation, oblige insurers to cover, if they offer BII cover, pandemics, prospectively or retroactively, the UK government felt that obliging insurers to cover COVID-19 related losses retroactively would most likely cause solvency issues with insurance companies, so it is perhaps not the most appropriate course of action. In France, the French government came out with essentially the same answer. They didn't think that was a very good idea. In the US, in a classic display of what I would call politicians' logic, we must do something, this is something, therefore we must do it. 12 states and the District of Columbia introduced legislation to oblige insurers to cover COVID-19 related losses. Now, these laws differed in their details, but essentially they all did the same thing: increased cover in existing policies, ones that have already been issued, to compensate for pandemic-related losses, a cover to be applied retroactively, defining property damages, including damage by viruses adhering to surfaces, being present in the air, etc., and voiding any exclusion clauses. And moreover, in some of the legislation, saying ignore the precise wording of the policy, it covers pandemic-related losses. Now, understandably, and as a lawyer myself, I would regard such retroactive legislation as bizarre, to say the least. But more than that, various insurers pointed out that any such changes would probably lead to the complete insolvency of the US insurance industry, at least insofar as it related to those states in question. And the states included some big ones. The International Association of Insurance Supervisors, so this is not the industry, these are the supervisors, the international ones, so it would include representatives from Hong Kong and the UK and elsewhere, the US. The IIS cautions against initiatives seeking to require insurers to retroactively cover COVID-19 related losses that are specifically excluded in existing insurance contracts. In such cases, the costs of claims against losses have not been built into the premiums. Requiring insurers to cover such claims would create material solvency risks and significantly undermine the ability of insurers to pay other types of claim. So much for your home insurance or health insurance or motor insurance, when your insurer has shelled out all of its money to cover COVID claims, which it didn't expect to have to cover. There are also questions of relating to the Constitution of the US, especially its retroactive nature. And as a consequence, at least at the statewide level, all of these initiatives fell by the wayside. The US government, or at least the federal level, Congress was examining a response on a federal level, which I'll come to later, but at least as far as extending BII cover, private cover on that sort of a basis, it's come to naught, because most people have recognized that it would actually destroy the industry, simply because such cover, especially retroactively, would be unaffordable to the insurer. What about private pandemic risk insurance? The OECD, amongst others, identified the challenges that insurers face when contemplating this type of cover. Now, what are those problems? Well, it's the fact that there is so little data for underwriting purposes. The fact that you would need to hold as an insurer, huge reserves or capital or both to meet the potentially huge losses? Remember, multiple claims, multiple locations, all at the same time, and possibly all at the same time extending over weeks, months, who knows, years. The inability, because of that, to diversify your risks. You can't spread the risk, which is one of the essences of insurance. The fact that because it's so expensive, not only to the insurers, but also to policyholders in the past to buy, the reluctance of policyholders to actually buy it because they think it would never be needed. And that reluctance is also built upon by the fact that everybody would expect, as has happened over COVID-19, would expect free government assistance. That 376 billion pounds spent by the UK government in the event of another pandemic. So these challenges have meant that insurers have, generally speaking, not ventured into the private pandemic risk insurance market. Now, some have. There was a product called Pathogen RX, or there is a product rather called Pathogen RX, developed by Marsh and its partners prior to the pandemic. Before the pandemic, and it depends whom you believe, they either sold one such policy or none at all. I don't have figures for how many they may have sold since the pandemic started, but in any event, it wouldn't cover the pandemic, of course, only future ones. I don't have the policy wording, and you wouldn't necessarily expect me to have it. There are fact sheets available. If you look up Pathogen RX, you can find them. There's different versions over the past few years. The current version would cover loss of gross profit, loss of revenue, and extra expenses suffered as a result of an infectious disease event in a designated geographical coverage area. And there are three triggers. World Health Organization issues a disease outbreak notice, or issues a public health emergency, of international concern notice, or the civil authorities, police, government, issue some form of restrictions in relation to the disease. Questions which arise over the nature of such insurance. What does it mean by infectious disease? We've already seen discussions about that. What does it mean by designated geographical area? What about the combination of these three triggers? And already we've seen the litigation over that one trigger, the government lockdowns in FCA and Arch. Now, this is not meant as a criticism of Marsh or its partners. Clearly, you've worked hard on developing this policy, and if anybody's got answers to these questions, they probably have. But other insurers may not be able to meet the challenges that Marsh and its partners have faced. In addition to all those other terms, again, what do we mean by outbreak, epidemic, or pandemic? All of these issues, you can define them in a policy, but they can still be litigated over. And if there's any degree of disagreement, there will be litigation. But that's not the only obstruction, getting the wording right. And of course, as I keep saying again and again, the wording is crucial. It's also the availability because of its cost. Numerous experts have pointed out that the most important problem facing the private supply of pandemic risk insurance is the large amount of capital required to make it credible. One estimate is that by Grundle in his team, Grundle, Guxer, in a paper, Insurability of Pandemic Risk, which was published by the Journal of Risk Insurance back in 2021, the shortfall of loss distribution for this type of cover, a pandemic cover for a small business, is 100 times higher than that for other types of natural catastrophe cover. 100 times higher. It's simply unaffordable for a private insurer. So, what about public-private pandemic risk? Hartwig and who examined this, and his colleagues said, well, there's essentially four ways of addressing a pandemic. You can have post-event assistance, which is what we've been doing. You can have a government reinsurer with primary insurers, commercial insurers offering primary cover, and then they buy reinsurance from a government-backed institution. A government-backed institution could offer primary cover, or you can rely on social insurance, welfare, to deal with it. And they said Hartwig and his team said there were basically four criteria by which you can judge the effectiveness of these approaches: operational efficiency, matching compensation with losses, risk mitigation, and the overall economic impact. Now, Hartwig and his team took the view that in terms of efficiency and macroeconomic impact, the social insurance, the government approach method was the best. Now, okay, I personally think that's a rather optimistic way of looking at the provision of public services, especially in my home country, the UK. But one can see why they would come to that view. In terms of risk mitigation and matching compensation with losses, insurance approach was the best. What the team didn't think of was what was actually happened, in that the fifth option was to discuss various schemes, and the OECD, in a paper in March 2021, listed at that point 16 schemes that were being proposed by various public and private bodies. You can talk about these schemes and then do nothing, which I suppose is a variation on the post-event assistance approach. And that's what's happening. There are various schemes that have been put forward to address the points made by Hartwig and the others, and by the OECD, which said there needs to be broad coverage. You need to limit public financial exposure. There need to be incentives for risk control. There is no such scheme in place, and also providing for rapid payments. There is no such scheme in place, a comprehensive scheme in place that addresses these issues. Some of the proposals that have come up have been very interesting. The Lloyd's proposals. Lloyd's, back in July 2020, issued a white paper supporting global recovery and resilience for customers and economies, identified three solutions to COVID and future pandemics. The first one was a short-term government backstop. Well, that didn't happen. The second proposed potential solution was to pool insurance capital to provide some of the capacity to cover the second wave of COVID. But we've had the second wave of COVID. That didn't happen. And its final proposal was something called Black Swan Ray. Black Swan Ray, events that come out of the blue, bad events that come out of the blue. A framework for governments and insurance industry partnership. Essentially what it would be focused exclusively on future systemic risks, beginning with pandemics, then possibly including other types of risks such as climate change and cyber attacks, widespread cyber attacks. But beginning with pandemics, there would be three layers of funds. The first layer would be the commercial layer, so the insurers, followed by an intermediate pool layer, and then a final government layer. So the government essentially is the backstop. And because the government would be providing the final pool layer, and because cover would be written on the basis of exclusively this type of risk in the future, Lloyd's anticipated that premiums would actually be kept to an affordable figure. But beyond that big picture, very little detail, or at least the detail that was there was simply raised as matters for discussion. Potentially, Black Swan Ray is interesting, but again, the devil is in the detail. We don't have the detail, and nothing's happened. I'm not blaming Lloyd's for nothing happening, but essentially, since the release of that white paper and a supporting paper, there's been no progress. I can find nothing on the Lloyd's website, or anywhere else for that matter, that discovers the development of this project. As I say, I'm not blaming people. Events move on. It may well be that Lloyd's met with very little positive response from the government. And in that respect, it's worth noting that government officials have not met the representatives of another industry initiative, Pandemic Ray, not a Lloyd's initiative, another one. Those government ministers have not met with the representatives of the industry for a year, since March 2022. It would seem that as far as the UK government's concerned, is they're not remotely interested in this. The US Pandemic Risk Insurance Act would have developed a pandemic version of the Terrorism Risk Insurance Act. It was proposed by a member of Congress on 2 occasions. And I'm not going to spend too much time on that because by the time the then session of Congress ended on the 3rd of January 2023, because this was proposed prior to the midterm elections, it only got so far as the House committee. It hadn't been voted on by the House, it hadn't been voted on by the Senate, there hadn't been any reconciliation process, which follows if the Senate and House disagree, at least not even got anywhere near being signed by the president. So that one has gone as well. So, conclusions. As I've reiterated throughout the talk, the purpose of BI cover is determined by its policy language. It may or may not cover a pandemic. That leaves a coverage gap. There's little indication that the market's got any appetite for developing private pandemic insurance. In fact, the market's tightening now because of more Nat Cat claims. In fact, Nat Cat cover is becoming tighter as well. So pandemics, they're probably not going to go for it. They may do. Marsh is still offering Pathogen RX. I don't know how many people have bought it, but even now, buyers are reluctant to pay for it. Why pay for something we'll never need, especially if it's really expensive? We've had one big pandemic, it's gone, and you don't need to worry about the next one. Well, yes, we do, but they don't agree. And there is no comprehensive public-private pandemic risk program in place. There are some smaller programs. There's a program in Hainan that began in 2020, not long after the beginning of the pandemic, but it was limited to key enterprises, and the amount of coverage was relatively limited. There are, dare say it, other little schemes in place in other jurisdictions, but there is no comprehensive scheme that meets the criteria set down by the OECD. So we are still where we were in 2008, in 2019, with Lloyd's warning us that a pandemic is inevitable and there's not much in place to deal with it when it happens. Anyway, I'm sorry to leave you with a rather depressing end, but I've always thought that honesty is the best policy. Anyway, that's all that ends my talk.